All rise. The Honorable Supreme Court of Georgia is now in session. Chief Justice Nels S.D. Peterson presiding. You may be seated.
Good morning, ladies and gentlemen. Good morning, counsel, and welcome to the Supreme Court of Georgia. Madam Clerk, do we have any requests for the admission of new members to the bar of the court?
Yes, Your Honor. The following named applicants have properly certified applications, and I respectfully move for their admission to the bar of the Supreme Court of Georgia.
When your name is called, please step forward and stand before the bench to take the oath.
Allison Altman, Lillian Andrews, James Arnett Jr., Zachary Ayer, Claire Anderson, Katie Anderson, Chital Brombat, Matthew Cooper, Gabriella Coricelli, Harrison Feinstein, Siri Faustin, Broxton Harvey Jr., Michael Hosea, Jay Jong, Luke Julian, Chandler King, David Colmel, Shanna Llewellyn, Carter Lewis, Jalen Marchand, Kimberly Marroquin, Michaela Manley, David McDonald Jr., Derek Law, Danielle Ortega, Dion Peoples Sr., Julian Pierce IV, Jennifer Podesta, LaShanti Robertson, Bren Routley, Olivia Salter, Matthew Schlager, Karen Sears, Jacob Center, Joy Smith, Robert Warren, and Noah Wilson.
Well, good morning. I hope you're all well this morning. Please raise your right hand and listen carefully to the following oath. You do solemnly swear or affirm that you will conduct yourself as an attorney and counselor of this court, truly and honestly, justly and uprightly, and according to law, and that you will support the Constitution of the state of Georgia and the Constitution of the United States, so help you God. If you agree to this oath, please respond by saying, I do. You can put your hands down. It is our tradition for one of the justices to offer words of welcome to our newly admitted members, and this morning that honor falls to Justice Bethel.
Thank you very much, Chief. I'm glad to see that word got out that I was giving the opening remarks. I really do want to welcome and extend congratulations to a large group of admittees. We are thankful that you are practicing. We are thankful that you are seeking admission before our court, and we look forward to that practice coming to fruition. One of the common themes of these remarks is to give thanks, to be thankful for what this day represents. Obviously, it's just a singular process, but it does create a punctuation mark or an opportunity in your life to look back and give thanks and maybe send a text or a call or an email or even a handwritten note to somebody who encouraged you along the way to say, today I was admitted to the highest court in the state of Georgia, and you were a part of that, and just say thanks.
such action. A committee may subpoena persons and documents, but it must do so consistent with the law and Constitution of Georgia. Now, we know in this state, since the time that Ellis Arnold was governor in 1943, that the General Assembly has said that it requires joint action of both the houses of the General Assembly, not just one house, both houses of the General Assembly to issue a subpoena. And in 2025, the General Assembly, exercising that power, passed a bill that allowed subpoena at the discretion of the Speaker and the President of the Senate. But it is not something that can be done just by one committee, one special committee, not even the whole Senate, and certainly not the General Assembly.
Counsel,
Yes.
can you speak to your, I think the argument you describe as mootness based
Yes.
on the different General Assemblies?
It is our contention the case is moot for two reasons. The first reason is the General Assembly that issued this subpoena is adjourned sine die. And under Mason's manual and established case law, the General Assembly cannot act after it adjourns sine die. Second reason that it is moot is that they have enacted a statute in 2025. Now, I will leave to another day whether I think that statute is appropriate. However, we, representing the district attorney, have acknowledged service on that subpoena and will appear on the 17th.
So, counsel, a question on the sine die piece. I think, at least as I would process the information, I don't know that you need that to be the rule. The more powerful rule, to me, in your posture, would be that when the 158th General Assembly convened, the 157th dissolved.
Correct.
Because obviously, the legislature still has power after it adjourns sine die, correct?
It cannot take official action.
It can call back into a special session if a governor refuses to call a special session, yes?
3/5.
And if there's a DOT vacancy, they can elect a member of the Board of Department of Transportation.
Yes,
so
but
they still have power, yes?
I don't mean to cut you
You're
off.
okay.
I don't argue with you about the adjournment and the reconvening when the new session, but that's happened in this case.
Yeah, I guess when
The 157th General Assembly is adjourned sine die, and the 158th General Assembly has met.
I guess what I'm trying to get a question is what is your perception of the importance, if you're right about the dissolution? I mean, we try to decide less, as little as possible, as opposed. Why would we need to talk about the sine die proposition in a world where at a minimum, the same arguments would apply to the dissolution and reconstitution, at least from my perspective. And I'm trying to get at what I may be missing, why that's important.
No, I'll take it any way I can find it, Justice Bethel. But generally, even with, and I won't get into this, but I served in the General Assembly for 22 years, and our rule was when you adjourn sine die on the second, particularly on the second session, the second year, then you were done. Now, there is a provision that special committees can meet, but they can report, but they can't take official action. And in fact, what was the general practice and procedure was, even if they had issued a report, that they would readopt the report in the new session.
So that first subpoena that was issued by the committee in '24
Correct.
was a subpoena calling for testimony to that committee of that General Assembly.
Correct. And documents.
And the documents issue is not before us because that's all
It's
been
not before us
worked out.
because we've worked that out.
If we were to decide that subpoena is now moot because the General Assembly and the committee of that General Assembly that it ordered testimony before no longer exists.
Correct.
We would not have to decide anything about the adjournment sine die, right?
No, you would have to decide nothing about that, and that's the cleanest way, in my view, and the correct way.
It also strikes me that there may be potentially another basis on which to conclude that this case is moot, and that is if the district attorney does in fact testify on December 17th, I presume your position would be she would be testifying under both that first and the second subpoena?
No, the subpoena has been reissued by the 25 committee, and we have acknowledged service.
So that word reissued is an important one. What I'm trying to figure out is what is the status of the first subpoena following the acknowledgement of service of the second subpoena?
I think it's dead. And the reason I think it's dead is because there has been a meeting of a new General Assembly.
In agreeing to appear under the new 2025 subpoena, has your client made any assertion about what authority she thinks she is testifying pursuant to? In other words, have you disclaimed that any authority from the 24 subpoena still exists, or have you just said we're showing up?
We're showing up. We're showing up pursuant to the subpoena that we acknowledge service on, which is the 2025. Right.
And so is it your position because you've only acknowledged service as to that subpoena, the only authority that could attach is pursuant to that subpoena?
Correct.
But you've also acknowledged the validity, the procedural validity of that subpoena in acknowledging service, correct?
I've acknowledged exactly what acknowledged service is, that I have been served with that subpoena and that I will obey it, that I will come. Now.
And that you agree to the procedural validity of it.
I agree to
the text of the acknowledgement of service, and there's some handwritten notes in the margin. The original text was, in acknowledging service, you acknowledge the validity of the subpoena. And I see the word procedural was added, which I presume is for the purpose of preserving all of these constitutional arguments.
Correct. And what it is, the procedural, Justice LaGrua, is this, that the subpoena was issued and that in lieu of service by the sheriff or any other person over 18 years of age, that we will accept it. And so that procedure is correct.
And counsel, just to clarify, any questions not related to the procedural validity but constitutional validity and these other arguments that you're making in this case with respect to that subpoena would be the subject of a new case or a different case, not this one.
And you may hear this again, because one of the things that Mazars, the Trump case, said and all, you can't you just can't pick somebody out and say, we're going to embarrass you, we're going to try you, we're going to harass you. So we'll make an appropriate objection at the time. I'm not a potted plant, and I can do that, and that will be before.
Well, and to that point, I understand that before the trial court, there had been litigated not simply the question of whether the subpoena was invalid in toto, but also whether there were particular subject matters where separation of powers or other constitutional doctrines may provide her a basis not to respond to individual questions. And my understanding is that the trial court essentially reserved those questions for assessment after questions have been asked and not answered, such that that issue is not presently before us.
It is not presently before you. It is an underlying question. But the federal cases, and there are many more federal cases because there's only been a handful of resolutions over the last 150 years, and they've been joint resolutions that granted subpoena powers. My favorite one is the convict leasing system from down in Macon. They granted them the power of subpoena, and apparently the legislators, when they went down there, got drunk. And so there was a complaint made to the chairman of the committee and says, you should take some action. He said, no, the General Assembly has adjourned, and therefore my power is gone. Cited in our papers. Your Honor, I'd like to reserve a little time for my rebuttal.
Mr. Belenfante.
Mr. Chief Justice, Madam Presiding Justice, may it please the court. The case is not moot. The fact that the General Assembly adjourned both as a just matter of the second legislative session and that the 158th General Assembly is now in session or soon to be does not render the subpoena void. This is not a traditional mootness case. The attack is that the subpoena is void, and there is simply zero constitutional text to support that argument, and there is no reason this court should adopt it now. Nor does the fact that the witness has agreed to testify on December 17 change the calculus today. We agree that if the witness comes and testifies and actually answers questions, it may. And we are under a professional obligation to notify this court that it has been mooted pursuant to Title V, and we will. But that's not the case today. Borrowing from the presentation, we remember that we had dates before and it did not work out. We hope that it does. So with that in mind, I'll turn first to that question of just general mootness and whether the agreement itself provides a basis to not decide the case. The answer is no. While there is no specific authority on legislative subpoenas to testify before a legislative body, this matter was before the Superior Court and therefore governed at least in part by the Civil Practice Act. But 91145 does not help. That's a subpoena for trial or deposition. And 91130 doesn't help. That's a notice of deposition. So looking at this court's precedent, Rogers versus State Medical Board from 1980 is a good example. Physician was investigated by the board. He subpoenaed documents of the board. In the interim, before he got the documents, the medical board dismissed the case. There was then no need to enforce the subpoena because the physician got the outcome he was looking for. That may be the case on December. I'm sorry, yes, Your Honor.
Let me ask you a question. The previous dates that were set, there was no agreement to testify, correct?
There was going to be an acknowledgement of service on those dates, we believe, yes.
But-
And there were unfortunate circumstances with trial that prevented that.
So it didn't occur. So
That's correct.
aren't we in a different posture now since she has agreed to testify?
We are. And it very well may be that on December 18, the appellant files a motion to dismiss as moot. We don't oppose it. And under City of Atlanta, case decision from 1914 or 1944, if we don't oppose it, it's accepted as true. But
there's a second subpoena that has been issued, service of which has been acknowledged. What is the status of the first subpoena following the acknowledgement of service of the second subpoena? Has that superseded the first subpoena?
it does not. And there is no language in the second subpoena that says that it, what was the word, reissued, that it reissues. It is a separate subpoena.
So recognizing that that is a different position from your friends across the way, in a world in which your position is correct, such that there are simultaneously two valid subpoenas, I assume you would agree that if she actually does testify on December 17th, that is testimony, perhaps not fully responsive to, but testimony pursuant to both subpoenas. You would not take the position that it somehow is only pursuant to one subpoena, right?
If this case is still pending before the court, I mean, we would take the position it is pursuant to the second subpoena,
But then-
which would then moot the first,
Well, but, I mean, okay,
because she has
today,
testified.
before the testimony on the 17th that we presume is going to happen, what can actually be done with respect to the first subpoena to the first special committee?
A couple things, Your Honor. And one is.
Because we agree that that special committee is, I mean, the people may be the same, but that has ended, right?
Yes and no, and this is a piece that I think is important and distinguishes this case certainly from the Nebraska case and some of the federal ones. The fact that Senator Cowser filed a counterclaim in his official capacity as a state senator to enforce the subpoena, and that provision was granted. There is a separate statutory.
Does an individual member of the legislature have standing to assert the interest of the legislature?
He could do so in his official capacity as chairman and in his official capacity as senator.
Was there any-
I've seen no authority.
Was there anything in the Senate resolution creating the committee that authorized the chairman of the committee to litigate on behalf of the committee?
It says that the committee would be authorized to enforce a subpoena, and the Senate committee's rules authorize the chairman to act.
So, unlike most other government offices, that is to say, there's an office of the district attorney, and whoever encompasses it, the office sort of operates in continuity. You would agree, and the Constitution clearly says that when the General Assembly convenes, it is a new General Assembly. It is not a continuous process. Correct? I mean, that is the rule. It's
The word different appears in the constitutional text.
The word different is there, but I don't think.
What does that mean?
It would be we know it means different things, for example, on a budget. A budget that is passed or is inchoate from a prior General Assembly doesn't then carry over the way a bill does between session 1 and session 2.
Well, that's not entirely true, because the state's fiscal year splits the calendar year, and so the 159th General Assembly, whenever, God hope we have one, right? It will have a budget that it is bound by, that was passed by the 158th.
It is bound by, but has the authority to amend in the amended budget.
Which is no different than the 158th can amend its own budget.
It could, but
So that wouldn't be, what I'm saying is, it wouldn't be a that wouldn't be a distinction.
Okay, well, forget the budget then. Let's just look at a statute. Bill fails perhaps on sine die, and on the last day in March, hopefully, of this coming year. It is not then brought back up anew in whichever chamber it rested in. It has to start the
It has to
process
start over because it's a different General Assembly.
It's a different General Assembly.
That kind of difference seems to me like there's no other place in the Constitution that I'm aware of that provides that, say, an executive branch agency or a court becomes different simply because the people constituting the entity change over. So, for instance, the Commissioner of Defects, there may be pending litigation against the Commissioner of Defects. Commissioner of Defects resigns, new replacement is put in, operation of law substitutes that new commissioner into the litigation for the previous one, because, so long as they were named in their official capacity, because defects isn't different, it's the same defects. Why would the substitution by operation of law argument that you're making, why does that necessarily carry over despite that word different?
Looking at the language of two statutes, 91125D and 4512, and admittedly, 45.
So before you go into what the statutes say, can a statute answer that constitutional question? I mean, if the issue is the Constitution says they're different, can a statute resolve that?
I think it can, and it speaks to what different means. And I think
But surely different doesn't mean same.
it does not mean same. I would not make that argument. And we see in other provisions of the state constitution where different is flushed out, whether it is because the statute is there, or whether it is in terms of an operation of law, or whether, for example, there's an exception for impeachments, that once they adjourn, that's where you address what happens after sine die. And it says the Senate can continue its impeachment trial.
It has to,
even if
right?
they adjourn.
It's not allowed to.
Yes.
But isn't it different if the constitutional language enables statutes to follow to give meaning versus just stating something is different?
It would, but here you run into another provision though. Because the power of the General Assembly is plenary, the default should be that the General Assembly can act unless expressly prohibited.
So sure, when we're talking about the General Assembly, I think part of the challenge here is, to the extent we're here over the first subpoena was not issued by the General Assembly. It was issued by a Senate committee. I don't think anybody disputes that the General Assembly's plenary power includes the General Assembly the power to subpoena, so long as it's exercised by both houses in the same way that the other powers of the General Assembly generally have to be exercised by both houses in tandem. And if you look to Senate Resolution 465 that outlined specific powers that were the basis for the committee, the first couple of powers that it itemizes were powers that I am confident you would agree can be exercised only in tandem with the House. Those were the power of making laws and the power of appropriation.
Correct.
I think we would be in a much more challenging constitutional space had the General Assembly not acted in 2025, both the House and the Senate, to confer this power of subpoena on committees that now has been exercised in this most recent subpoena that service has been acknowledged. So you would agree that we don't actually have to answer the question of the extent to which one chamber can do that without that having been authorized, because that's not the world we live in anymore.
I think for the subpoena that is before the court would need to answer it. And potentially, I'm sorry, Justice Bell,
please.
potentially going forward, just because Senate Bill 255 passed, it is not the only vehicle by which the Senate or the House or its committees could subpoena. And subparagraph E or subsection E of the code makes that very clear.
But it's the only one pursuant to which they have, right?
It is not, I would say that the others are available. I think that, when we get into 45-117, where the power was exercised jointly, that makes sense because that legislation passed in 1943 and has not been changed since, and there was not the provision against the General Assembly limiting.
But this most recent subpoena, the acknowledgement of service that was entered into, in the last week.
Yes.
That was issued pursuant to the new statutory authority, correct?
The new statutory authority and the new resolution,
Right.
Which continues the prior committee.
Well, I mean, it doesn't expressly continue it. It says it's a successor, right?
I think that might be the phrase, but I mean, it's certainly I think it's spoken of as it redoes, but it's the fair point. But again,
So I want to rewind to the mootness argument a bit, because that's the piece that I'm wondering about. The first subpoena was a subpoena from the special committee of the 157th General Assembly.
correct.
Now we're in the 158th. We have a new special committee, or call it a successor of the 158th. That first subpoena, there's no committee that still exists for the district attorney to appear before, right? If it was a subpoena from that committee that no longer exists, from a General Assembly that no longer exists.
I think that it could because of reading the Constitution in conjunction with the two statutes that I talked about, that you submit or you just substitute the public officers and the counterclaim that was there.
That's true for litigation. Like, assume you're right that for litigation purposes, the parties have been sort of substituted for their successors. Their successors were substituted. That doesn't necessarily change the subpoena itself, right? If the subpoena is a subpoena from a committee that no longer exists, then that subpoena is no longer of any effect, right?
I would disagree. I do think
I
the
figured.
subpoena, yeah, I do think the subpoena is still of effect. And to your point,
Okay, if a subpoena was issued by an agency of the state, and before the subpoena was satisfied, the General Assembly, bicameral presentation, effective on signature, passed a law abolishing that agency and not accounting for any outstanding legal liabilities or responsibilities. The governor signs it. How would you satisfy that subpoena, or would you be under any obligation to satisfy it?
I think it's difficult because I've seen enough of those where they typically continue
assign it,
over, but presuming they don't
because
do
they
that
have
at
to
all.
say, that's right,
Right.
they haven't done that.
You run into, I think, administrative subpoenas at that point would be different, and there's different analyses that go into what an administrative subpoena is and does.
So what power does the 157th General Assembly have today?
A power to pass a bill? None. A power to effect appropriations? None. A power to see that his will was enforced and not simply delayed through litigation. And this, remember, this was a trial court that moved quickly.
If a member of the 157th General Assembly's Senate sat on this committee that issued the subpoena, and somebody said, I'm going to come testify and satisfy that, and they showed, and so they're no longer a member of the Senate, and they showed up for the committee hearing, what power would they have in the committee hearings room?
To ask questions.
Yeah, that senator would not have the authority, but I
So
think
why
that's
isn't the committee different?
because I think the key here is the counterclaim, where you don't have to answer that specific question, because the counterclaim to enforce, which was part of the final
But it's
order.
to enforce a subpoena, you do have to answer the question, because it's to enforce a subpoena that may have stopped having any force of law in January of 2025, the minute a new General Assembly was convened.
Because a subpoena isn't simply an abstract subpoena. It was a subpoena to testify to the special committee of the 157th General Assembly. That committee no longer exists, correct?
That committee as in, well, the 157th General Assembly does not exist, so the committee.
So a
But
committee of the 157th.
I would argue the committee has been.
I understand you argue
Right.
that the committee of the 158th is its successor, and so it sort of continues to,
I mean, saying that it's its successor is as a descriptive term, probably true, right? I mean, it is the colloquially successor entity. Whether that means the General Assembly is a different General Assembly, though, is not, I don't think is answered by the colloquial description of that committee being the successor committee.
And again, I mean, certainly, this is why it's an issue of first impression, and the ability of the court to decide that, I think, will be important. Again, maybe it won't have to, we'll know in a couple of
although we
weeks.
do have pretty strong prudential rules around not deciding constitutional questions of first impression if it's not necessary.
Correct, which is why I think the statutory basis to operate, whether it's 9/11/25 or 45-1-2, allows the court to avoid the constitutional question. Or the court could decide, and I think very reasonably under the authority we have, whether it's the anti-stalking provision discussed in Little or the election code in the Gwinnett Place case, that this would not be mooted because it would be susceptible to repetition, and it's
So
not
it's certainly
moot.
capable of repetition, but I don't see how it would be evading review. I mean, the problem in this case was the subpoena was issued late in the year, the second year of the biennium. If you issue a subpoena in February of the first year of a biennium, that is ample time for the courts to decide all of the enforcement questions, right?
Conceivably, unknown. The committee met in
I have
February.
great faith in the capacity of
The
the courts
committee
of this
met in
day.
February, March, and May, heard from the defendant's counsel in the case, heard from Fulton County on the budgetary issues, and then heard from district attorneys after session. And with that knowledge, then wanted to hear from the district attorney. But imagine this, and it's not hard to really do this. Let's say we're in the last 2 or 3 weeks of session and a major issue pops up, whether it's COVID, whether it's AI.
Well, that might in fact be different, but it doesn't seem like that's the factual scenario that's happened here.
And even if it is different, right, I mean, there's going to be another General Assembly coming. I mean, this is how the system of government works, is that we share power. And so in 2 weeks' time, a new General Assembly will convene. They can issue whatever subpoenas need to. If you have somebody that's openly flaunting the General Assembly's authority, whatever the authority is, you can ask somebody in the House to file an article of impeachment. And I mean, there are other tools available to move the process along.
If it's a public official, that might be available, but otherwise, if there is that late breaking provision, and then you go to trial court and you deal with the suppress issue or the motion to quash, like we did here on a preliminary basis, then on a fully briefed basis, then on a fully briefed basis with objections noted and decided, then.
Although part of that is just the fact that it is not the traditional function of the General Assembly to engage in that kind of investigative efforts. I mean, that is not, I mean, a number of us have been around in this world for a while. That is not traditionally how the General Assembly operates.
I'm not sure that weighs against it, And in addition to
It
that,
certainly weighs against whether it's likely to evade review, it seems to me.
it's possible, but I think there's a lot of differences in the way that, for example, political parties work or witnesses are doing more now than they were before. And to their credit, the appellant, had a great discussion of how the General Assembly operated before the Constitution was changed and said a statute cannot limit its authority. But it
Counsel, I
did
have a
happen
prac-
and can
be-
happen.
Before you finish, I have a
Yes, Your Honor.
practical question. If the 17th comes and the witness does not appear, I assume you will go back to Superior Court to enforce that subpoena as well?
I think we would have that option and start the whole process over again, and that's one reason why this court should decide the issue now.
I have one more question before you step down that I did ask your friend across the way. The question of scope is not presently before us, right? My understanding is the trial court expressly reserved the question of what would happen if she appears, but specific questions are not answered. And you would agree that's not before us?
It is not before you, but it is also not before the trial court because there has been a final order entered. So if there are...
There would need to be a new enforcement action pursued in the event that happened.
That's correct, Your Honor.
Okay, thank you.
Thank you.
Very briefly, if I may, my distinguished brother here wants you to issue an advisory opinion. That one house or a committee or a special committee can, regardless of the 25 statute, can issue subpoenas. And that simply is not before you. I mean, that issue has been mooted. And this argument, well, there are some ways that you can go past the different, in the words of the Constitution, General Assembly and enforce something is simply not supported by law, case law, or the Constitution. The General Assembly dies and has no further effect when a new General Assembly comes in. I would suggest when it adjourns to sine die, even though it may be recalled. And this business, well, an impeachment trial. Oh, one body can do an impeachment. Yes, but that is specifically set out in the Constitution. Same thing with the budget. The budget must be introduced in the House. All tax measures must be introduced. Not because they want it that way. It is because the Constitution requires it.
Well, and in the context of the budget, the act of passing the budget is the appropriation. There's not really a continuing appropriating power. It's just the appropriation occurred, and then it can be amended later on.
Right. And this idea that both committees, I think it was Justice Penson or Justice LaGrua, both committees are successor and are finished and all that stuff. These members are not the same. There is at least one member who retired in between the two General Assemblies, is not a member of it. So
Counsel, I think I heard your friend across the way essentially say that if the district attorney shows up on the 17th and testifies, from their perspective, that functionally satisfies the issue that's before us, whether we all agree about that. So would you agree that, notwithstanding the other mootness arguments, that would moot the issue that we're...
you got a bunch of folks on this committee that's running for statewide office, and they're putting out fundraising information. We're going after Fani Willis. Those are issues that we will take up in a later case when they've been formed. Thank you.
Thank you very much. Counsel for both sides. It's well argued. We will get you a resolution within the time required by the Constitution, and we look forward to a status update following December 17th.
Thank you.
Madam Clerk, please call the next case.
S25G0922, Richard L. Jackson et al. Versus Mark Stevenson et al. Jay Bogan for the appellant and Rocco Testani for the appellee.
Counsel, inexplicably, the press seems to find arbitration less interesting, so let's give them a moment to step out if they're going to step out. Counsel, you may proceed.
May it please the court, Jay Bogan for the defendant's appellants. I'd like to address the key points. We have a foundational principle at work here, which is dragged into arbitration against its will, would eviscerate the requirement that arbitration be based on consent, not coercion. Getting to the first question presented by this court, under what circumstances can an entity that is not a signatory to an arbitration agreement